off on putting your contact information in. We'll do that later. For now, Scott, take it away.
Thank you very much. Welcome everybody to WBC, the Wednesday Breakfast Club, where we meet on the second and the fourth Wednesday of each month, and on occasion have a topic of interest that one of our members gets to speak about. But today we have a special treat because we're going to get to have a little Q&A with the amazing Richard Agins from Agins Law Firm right here in Arizona. You know, originally from Connecticut, now in Chandler, there's a big move there, and he runs a practice that focuses on what we as business owners all need more information about, whether we're talking about contracts, bankruptcy, immigration, business law. He manages all of this, and you're going to hear more about that as we get to meet Richard. Good morning, sir.
Good morning, and just a slight correction. I'm
Please.
originally from Manhattan in New York, but when I became a lawyer at the age of 53, I began my legal career in Connecticut.
Ah, but you see, there's no alliteration between Manhattan and Chandler. If you had lived in Mesa, then I would have mentioned Manhattan and Mesa.
My bad, sorry.
It's quite all right. You correct me anytime because we want to get it right. And as a matter of fact, I happen to know that I've already kind of goofed up here a little bit because your current practice is really business law, and you're not Perry Mason. You're not Matlock. You're not going to help me if I get arrested and I've got handcuffs and bars behind me. But you can help me to stay out of jail by having a business practice that is done legally and properly. How am I doing?
You're doing almost completely well, except that the other major part of my practice is estate planning.
Correct. And we're going to talk about that as well. But a curious question, because I'm going out of order here. Estate planning, is it just for people who have money?
No. Estate planning is for anyone over the age of 18. Anyone. Because an estate plan is a compendium of different documents. You have a will, which everyone should have. In many cases, in order to avoid probate in Arizona, you would want to have a trust, be it revocable or irrevocable. And then, of course, you want to have your powers of attorney, both financial power of attorney and healthcare power of attorney, and also maybe an advance directive, sometimes called a living will, and a HIPAA release authorization. And that is an entire package which protects both your assets and your health.
And put somebody in charge of making those health decisions if you're incapacitated. Is that correct?
That is correct. Very often you will hear the term conservator of my estate and guardian of my person. And that basically says it all, that you have assets and you have yourself. And you yourself are often your biggest asset. So you want to get that, make sure you're protected.
You know, I try to convince my wife that I'm the biggest asset, but I don't think she quite gets that idea just yet.
So this come around, Scott.
Thank you. 30 plus years, I'm not so sure, but thank you. Estate planning, again, so 18, I'm assuming that they don't necessarily need to have any amassed wealth, but they still should have this planning done. Is that what I'm hearing?
You are hearing correctly, because once you reach 18, your parents are no longer automatically your agents. So in order to convey your powers of attorney to your parents, you have to have a written power of attorney.
Okay, so what else can we talk about estate planning as it relates possibly to business owners?
Well, obviously, when you're a business owner, that is, aside from your house, or maybe instead of your house, your business. And you should, of course, have a succession plan for your business, and you should have an estate plan. So when you die, there is a plan to transfer management, ownership, and vision for the firm to someone else. I have a client right now, a business client, who I've been working with for the past 3 or 4 years. And his wife called me last week and said he has been diagnosed with terminal cancer. And he's already in hospice, and they didn't have an estate plan. And of course, they did have a succession plan because I had constructed that for them previously. So I got together with the wife, who was going to be running the business, and we went through all the details and made sure that there was a plan in place, both with the Arizona Corporation Commission and internally, to make sure that business continues running as he would have wanted it to once he's gone.
And is it assumed that the spouse has the power of attorney and control over the trust, or
No,
does that need to be written?
Well, she is a joint grantor of the trust. So yes, she has control over the trust once he's gone, but certainly she does not automatically have power of attorney over the husband's estate or assets or health simply because they're married. In order to effectuate that, the husband had to convey to her powers of attorney.
Convey verbally or convey?
No, conveyed in writing.
That's what I thought. Okay, very good, very good. And it's, I'm assuming, different in every state, or is it the same in every state?
Generally, it's the same in every state. The details may vary from state to state, and of course, the requirements may vary from state to state. But the fact that you need to have some instrument to convey your power to another individual is universal.
So as the attorney of record for people, whether they're businesses or individuals, for a state or business, is this something that they need to have an attorney like you on call all the time? Or do you review this periodically, or you set it up and it's done?
Well, estate planning is not an event, it's a process.
Oh.
And as such, it's an ongoing process because an estate is a living organism. Even after you die, your assets continue in existence. So you want to make sure that any vital change in your circumstances, whether it's a marriage, a death, a birth, a new house, new job, new investments, that all has to be encompassed within your estate plan. And I tell my clients, we should review that annually, but certainly no less frequently than every 3 years.
Okay, so anytime there's a life event that happens, and I'm assuming that you work hand in hand with a financial advisor or other business professionals?
I say that an estate planning team is a tripartite structure. You have an estate planner, an attorney, you have a financial advisor, and you have a CPA. And I would mention that for the first 40 years of my career, I was a CPA. I'm not anymore. I'm licensed, but I don't practice accounting anymore. But of course, coming from that background, I always view an estate plan through a financial prism.
For networking purposes, because we all like to share referrals with one another, are you comfortable working with someone who already has a CPA, but you can refer them to the other part of the triad?
Absolutely.
Okay.
Absolutely. I always enjoy working with people who have a team, because that way there are no surprises, no one gets broadsided, and you get complete advice. Because I'm not going to give accounting advice. I'm not going to give financial advice. I will give legal advice.
Excellent. So I'm curious, because we hear this term of power of attorney all the time, but there's more than one type. Is that correct?
There is a financial power of attorney, sometimes called a general durable power of attorney, which deals with your assets. And then there's a healthcare and mental health power of attorneys, which deal with your person.
And these conveyances that you refer to, I'm assuming that they're professional documents. Do they have to be done by a professional attorney, or can I just, take my piece of paper and write down, I hereby will and testament to my wife, everything I own?
Would you write your own prescription for medication?
Ooh, bravo, bravo. I like that a lot. Okay, excellent.
Now, in all candor, Scott, I would say that the state of Arizona does have a statutory general power of attorney and a statutory healthcare power of attorney. And many people choose to just go with those and hope for the best. But as always, I do what I do because I have experience, because I study, and because I try to keep abreast of all the most current developments. A layman is not going to do that. So in that case, you're sort of, if you deal your own cards, you're dealing with the half deck.
Very good. And an attorney who has him or herself as a client?
Should not.
Should not. There you go. Very good. So everybody should have a professional.
But you should not.
All right, so let's talk about businesses. I always have this funny thing about small business. I listen to Marketplace. I'm a big fan of Kai Rizdal. He's the host for that show. And he talks about small businesses, but he's talking about a business that has 100 employees. I don't think of that as a small business. I think of that as a, medium-sized business. Small business is mom and pop, or a solopreneur, if you will. So give us some examples as to, what the business size would be that would be in your zone that you could help them. Are we talking about solopreneur? Or are we talking about 100 people in the business?
Well, we would, of course, be talking about sole proprietorships, because one of the things that I do is someone comes to me and says, I'm a widget maker, and I'm going to open my own shop. So how should I do this? Well, should I be a sole proprietor, an LLC, a corporation? What should I do? So that's something that I can counsel them on. You may want to have a partner, in which case you would be a partnership. You may want to have a team of people, in which case you're still a small business, but you could have possibly 10 owners. So I recently did some work for someone who was affiliated with one of our WBC members. And this is a new company, and there are multiple shareholders, let's say, or members. And he wanted me to review the agreement for him, which I did, and it was well drafted, no problem. But he came to me, and I felt good for him and good for me that he actually came and sought legal advice. So
it's always important to have a third party that's not biased review contracts, documents before you sign them.
Correct. And any well-drafted agreement into which someone is entering de novo as a new party should have a clause that says this agreement has been drafted by so-and-so for so-and-so's benefit, and you as an entering member or a participant have and should engage in the legal right to have independent counsel review it for you.
Wonderful. So I know that you can help them determine whether or not the business owner needs an LLC or an S Corp and so forth. You're going to put those documents together for them as well?
Yes.
And what other kind of business documents do you help us with?
Employment agreements.
Well, hold on. What's an implement agreement?
Employment agreement.
Yes. Okay. Thank you.
Non-disclosure, non-compete agreements, buy-sell agreements, purchase and sale contracts, just to name a few.
Excellent. And somebody's asking something about how do the succession plans vary between Inc., LLC, and I'm not sure if I understand the question. So you're the attorney. Does that make sense?
A succession plan is a plan for continuing the business. The mechanics will vary depending upon whether there's a transfer of membership interest or a transfer of shares of stock. So of course, in that regard, LLCs and corporations are different. But ultimately, the goal is the same, to make sure that there's continuity of ownership and continuity of management and continuity of vision between the selling or departing owner and the buying or purchasing owner.
Okay, so our good friend Micah from Colorado, he has a living will and an MDPOA, which I have no idea what that is. And he's curious because he's got this in Colorado. Is it valid in Arizona and other states? take a breath.
This is a question I often encounter. And the truth is, if it was valid in the state in which it was drafted, at the time it was drafted, it will be valid anywhere. However, some of these documents refer to statutes, and they generally refer to state statutes. So if you have a Colorado power of attorney and it refers to Colorado law, when you come to Arizona, it's like, well, what's that? I don't know what Colorado law is. So I always advise my clients, it doesn't cost that much money. Update your power of attorney, get it current in the state in which you reside, and that way there are no questions. Because the last thing you want is to need a power of attorney and have one that doesn't work for you. Just bad business.
which we all want to avoid. So tell me this concept in closing about periscope vision.
You know, I have been doing what I've been doing for a long, long time. And as a result, I tend to have seen not almost, but many, many, many problems that people would not either anticipate or recognize until they come and bite them on the nose. So my periscope vision allows me to see around corners and say, oh, that's a problem coming up. Let's plan for it now before it becomes a real problem. And
excellent. And you utilize that vision every 3 years or so when you're reviewing people's documents. That's what you recommend, every 3 years or so?
For estate plans, yes. Business plans, businesses are vital, and you never know when something's going to change. So always be in touch with your attorney, CPA, financial advisor, to make sure that any of the changes in your business are backed by the proper documents and plans. You know, if your tax situation changes, you don't want to keep filing the same tax form you did 30 years ago. You may want to update to something that's more relevant. So in that regard, yes, always keep current. That's one advice to my clients. Keep current.
Outstanding. Well, thank you so much for taking a few minutes to spend time with us today at WBC. Share your talent and your information. If you have additional questions, we'll drop Richard's information into the chat, and you can contact him directly, as he likes to keep everything confidential. Thank you so much, Richard.
Thank you, Scott, for the opportunity. I appreciate it.
Back to you, Rose.
Thank you. I took a couple of pages worth of notes myself, and I hope that a couple of other people in this audience did the same. We're going to go to breakout rooms, and these are going to have topics. We'd like to continue on this discussion